Well, good evening, everybody. My name is Erin May Quade. I use she, her pronouns. I'm the Special Projects Advisor at Gender Justice. And joining me this evening for a chat about Skrmetti, the Supreme Court case, are my esteemed colleagues. Brittany, would you like to introduce yourself?
You betcha. My name's Brittany Stewart. My pronouns are she, her. I'm a senior staff attorney and glad to be here this evening.
Jess, over to you.
I'm Jess Braverman. I'm the legal director at Gender Justice, and I'm equally glad to be here with all of you.
And it is, I don't know if everyone is in Minnesota or if we have some North Dakotans or folks from around the country, but it is cold and windy here in Minnesota. So it's good to be with good people.
As cold as Justice Alito's heart.
Oh, yes, that is on the nose. So we will be talking about Skrmetti this evening. Just a note for our folks who are joining us, this is going to be recorded for our podcast, the Gender Justice Brief. So know that this will come out in our podcast in a few days. So today, the Supreme Court heard oral arguments in US v. Skrmetti, which is a case that could affect access to gender-affirming care for trans youth, specifically in the state of Tennessee. And so we're going to talk about what happened today in court. We listened to the oral arguments, which were lengthy and difficult at times to listen to, but my crush on Elizabeth Prelogar remains and continues. And then we'll open it up for question and answer. So Jess, I'm going to come to you first. Can you just give us a brief background on, I believe it was SB1, the law in Tennessee, and then what happened to it that got us this case at the Supreme Court?
Yeah, so Tennessee was one of a number of states. I believe it was somewhere between like 19 and 23. I can't remember. Brittany, do you know the exact number of states?
I believe we're at 23 at the
Okay.
moment.
Thanks, Brittany, that have banned gender affirming care across the country. Um, a number of those bans are being challenged. Arkansas's ban was successfully challenged in the Eighth Circuit. That's the federal court system. The appeals courts are in circuits. So there's like the Ninth Circuit, which is the West Coast. There's the Eighth Circuit, which is Minnesota, North Dakota, South Dakota, Arkansas, Missouri. And so Arkansas's gender affirming care ban was struck down by the Eighth Circuit. Tennessee banned gender affirming care. The Sixth Circuit upheld the ban, unfortunately, um, basically saying that Tennessee can ban gender affirming medical care. The issue in the case, it comes down to it's an equal protection case. So most equal protection cases come down to what's called the level of scrutiny that the court applies. So let's say the court regulates something kind of neutral like bowling balls, right? The court says we hereby ban red bowling balls. That's going to be subject to rational basis review, and as long as the legislature has some reason, some even hypothetical, that would justify banning red bowling balls, they'll get away with it, right? When laws target make sex-based classifications, they're actually subject to a higher level of scrutiny where the court actually looks into why does this ban exist? Could it really be more narrow to achieve their goals? You're supposed to do a more exacting level of review. This case comes down to what level of review will the court apply to a gender-affirming care ban. It's a law that on its face makes what's called a sex-based classification, meaning on its face, the law says like whether or not you can access medical care is based on your sex. That's typically scrutinized by courts at a high level. The Sixth Circuit didn't do that, and this court seems to not want to do that either. Which means that we could end up in a situation where courts are extremely deferential to gender affirming care bans. I know it's difficult, it's a lot of legalese. I think what people hope we're talking about, and what Sotomayor talked about, right, is the impact of the ban on actual human beings. But because this is the Supreme Court, instead we're talking about levels of review and legislative deference and things that aren't like what really is at the heart of this, which is that people are being heard. And so at the end of the day, the question is the court going to allow this ban to stand? Is it going to closely scrutinize it? And it has even bigger implications than that.
Well, thank you for walking us through it. And I think one of the questions that a lot of folks will have is how far reaching could the decision be? Would it only impact trans youth in Tennessee? Could it have national implications? Would it have implications in the states where they've passed bans, but they've been challenged in court and the challengers have won? Like, tell us about what could happen when a ruling happens,
The-
regardless of what that is.
The really important thing to keep in mind for folks is that if Skrmetti does not come down in the way we want, it does not mean that gender affirming medical care is immediately banned across the country. So I just want folks to know that like it's not like opinion day in Skrmetti is the day that your health care is taken away. That's just the first, I think, and maybe most crucial thing for folks to keep in mind.
Is that true in
Skrmetti,
Minnesota
oh, yeah.
and North Dakota?
I'm sorry?
That's true in Minnesota and North Dakota?
Well, that's true in Minnesota. Right now, North Dakota does ban gender affirming medical care for adolescents. But that's because North Dakota banned it. There's a few different things to also keep in mind. There are right now state level protections in some state constitutions. So right now we're arguing that North Dakota's constitution should protect gender affirming medical care. So in states where you can convince a court to find state level constitutional protections, no matter what happens in Skrmetti, that right can still be protected. Our case in North Dakota is not done yet. Brittany's going to talk more about it. If you live in a state like Minnesota that has not banned gender affirming care for minors, then when Skrmetti comes down, it's the same thing. Minnesota hasn't banned it. It's still legal here no matter what happens in Skrmetti. The case could have really far-reaching implications, however, if, for example, there's some sort of federal ban, the logic in Skrmetti would make it very difficult to challenge a federal ban under an equal protection theory, which is probably the most strongest and obvious theory that you would go with. So it would mean that for future bans, we'd have to find different creative ways to challenge them, but we'd lose probably the strongest and most obvious tool in our tool belt, which is an equal protection challenge. The decision could go way farther though than trans rights, because we know a lot of judges don't even believe that sex-based classification should be illegal. So imagine a situation where, and it wasn't that long ago, right, where states barred women from jury service, or the Virginia Military Institute said that women can't be students here. Courts have struck down those bars because they're sex-based classifications, but we know some judges think those bars should be upheld. If the court here goes even further, it might just say, like, we're just not, we don't care if they're sex-based classifications. We're just going to allow them across the board. That's maybe one of the more extreme outcomes that we could see in this case. But the important thing for folks to keep in mind is that on the day Skrmetti comes down, your rights in your state won't necessarily change. If you're in Minnesota and gender affirming care is legal in Minnesota, Skrmetti doesn't change that. If you're in North Dakota, we're still making the argument under the North Dakota Constitution. Skrmetti doesn't force North Dakota to make a different, to agree with them under the North Dakota Constitution.
That's really helpful. And I think we should talk a little bit about what was said today at oral arguments. And you talked a little bit about how, you know, this is actually kind of the legal question before the court isn't like, hey, should they ban gender affirming care for minors in Tennessee or not? It was, is it a sex-based classification that is not permitted under the Equal Protection Clause of the 14th Amendment, right? And should the scrutiny given to this law be heightened because it's on sex-based classifications, not, you know, is it constitutional or is it not, right? And am I saying that right?
Yeah, so there's this old case that has reared its ugly head. It's from the 70s. It's called Geduldig, where basically the court said that bans on, let's say there's a pregnancy, let's say there's a comprehensive disabilities benefits plan at your work. And your employer says, well, we're not going to give you pregnancy benefits. We're going to exclude pregnancy. People came to court and said, obviously, this is sex discrimination. And the court said, no. banning healthcare that only one sex can access. And I'm using the court's words here. We all know that trans men access pregnancy care, but this is, the court was not, in its world of human beings in the 70s, the court was not even anticipating trans people. So the court was only thinking cis women, cis men. And what the court was saying is like, in this limited world that they're envisioning, even though only women access pregnancy related care, if the policy bans pregnancy, that's not sex discrimination. It doesn't say sex in the policy, it says pregnancy, right? And so the court let that go. That case was so ludicrous that like the federal government amended anti-discrimination laws, Minnesota amended anti-discrimination law to be basically like, what are you talking about? Of course, pregnancy discrimination is sex discrimination. Geduldig has reared its head in Dobbs. So when the U.S. Supreme Court overturned Roe versus Wade, Justice Alito basically said, like, hey, don't you come back here and try to revive these rights under a sex discrimination theory. Abortion bans are not sex discrimination. We're not going to do that. In Skrmetti, what we're seeing is basically the judges saying, gender-affirming care bans, even though they talk about sex on their face, right? Like the question of whether or not a kid can get testosterone depends on whether that kid was assigned male or female at birth. That is a sex-based classification. But the court seems poised to say that it's not going to it's going to basically pull a Geduldig. It's going to basically treat these sex-based classifications as though they're neutral because this is healthcare. It doesn't make sense. It's not rational. It's inconsistent with how courts have done things, but they do seem poised to do that.
Yeah, and I think we should get into the arguments made today because it was wild to listen to. Let's talk first about my love, Elizabeth Brittany Logar. She was, as usual, perfection. She was concise, she was clear, and it was easy to understand, right? Like, I'm not an attorney. I'm with two very esteemed colleagues who are attorneys, but I'm not one. And I was able to follow almost everything that she said. And so why don't we start with the US, right? So what was the government, the United States position in this case?
Okay. We are Solicitor General stands over here.
Yes.
She makes oral arguments seem really easy when in fact it's really hard. So her basic argument was that if the whole point of this law is to stop people from changing something about their body to be inconsistent with the sex they were assigned at birth, then of course that law classifies based on sex, and the court should subject it to a higher level of scrutiny. It shouldn't just say like rubber stamp, you can do this, right? It should see, is this law really written in a way that's limited to the concerns that the legislature has? Are these concerns even valid, right? The court should be doing this analysis because there's a sex-based classification. That was really the crux of her argument, and I think she made it really strongly in so many different ways and in different hypotheticals. She made it pretty clear that that's what's going on with this law.
And, when the questions opened up to the Solicitor General, there were many, many detours. And I think there was a comment in a question basically that like anti-trans wording kind of derails like the way that people think, especially these justices think about like the law and how they've applied it at precedent like every single time. And we saw that happen over and over where it was like, there was a hypothetical given where a patient who was assigned male at birth can go to the doctor and be prescribed testosterone to deepen their voice, but a patient who was assigned female at birth can't go to the doctor and be prescribed testosterone to lower their voice. The only difference is the sex classification, right? Like that's the only difference. It's the same medicine, it's the same purpose. The only difference is the sex assigned at birth of the patient. And yet, when these justices were asking questions, they were bringing in all sorts of really wild things. Do you want to talk a little bit about some of the things they were bringing up, and then maybe some of the rebuttals or the things that were said in response?
Well, I think that the justices they talked a lot about, they misconstrued what was going on in Europe. And so the justices kind of bought this false story that European countries like the UK, Norway, Finland, Sweden are banning gender affirming care when that's actually not the case. all of those countries still acknowledge that gender affirming medical care may be necessary for some minors and should be provided on a case by case basis where it's actually necessary for the minor. But the justices, Alito, Thomas, seemed really taken with this false notion that these other countries are banning the care. And they kind of buy into this idea of like, well, if it's controversial, then why should we weigh in? But there's two obvious answers to that question. The first is you can't create a controversy and then be like, look, there's a controversy. So it's one side, it's a group of people who are creating the controversy and then pointing to the controversy they've created to be like, haha, it's controversial. And that's just so transparent and so wrong. Um, the other issue there is like that those countries are not actually banning the care. And so they're wrong on a number of grounds. There was a question in here also about detransition rates and regret rates. Um, there are false studies claiming that there's like an 85% detransition rate for gender affirming care, and that's simply untrue. Those studies are, first of all, they're not studies of people who've gotten gender affirming medical care to begin with. And they're also studies of people who are not diagnosed with gender dysphoria, but who were diagnosed under earlier versions of gender dysphoria, like gender identity disorder and things of that nature. Um, they include prepubertal kids who do not receive gender affirming care now. So the 85% number isn't like 85% of people who get gender affirming care in 2024 regret it. It's like a fantasy number that kind of has nothing to do with the question of whether we should ban gender affirming medical care. There are other studies that actually study more on point populations, like people who actually do access the care. And the percentage is somewhere around like 1%, which, as the person in the questions, I think, I don't know if folks can see the question, but someone said, I heard multiple times they asked about regret. But there are other procedures like knee replacements that have higher rates of regret, and that's absolutely right. And so the thing to keep in mind is like all medical care carries risks. That's the whole point of informed consent. There are risks to taking Tylenol, there's risks to taking aspirin. You just have to be informed, and then you make your decision about what you want to do. And that's how healthcare is delivered. It's no different from gender affirming medical care. And there are not high regret rates. And so there was a lot of questions of, are we really going to ban this care for everyone when there's a 1% regret rate? We don't do that for other care.
Right. And I mean, if the legislature and the courts were in the business of legislating away regret, marriage would probably be banned, and knee replacements, as you mentioned. Bangs would be banned as well. I've regretted those many times in life, but that's not the goal of the legislature or the courts. And I think, bringing up people who've, evolved and transitioned back to their sex assigned at birth, it was a really distracting, and Justice Kavanaugh kept asking, like, you believe in detransitioners, right? Like he was like asking every person, and no one said that they didn't, right? It's just not, it wasn't the law at hand. And the length of time we spent on European countries as a country who declared their independence from England, like it was very, very weird to be like, let's just talk about the UK this whole time. And I was like, where are we? Brittany, you came off mute. Did you want to add something?
I did a little bit. First off, yes, on the Europe thing, like these folks like don't want to look at European healthcare in any other context because that would mean making sure everyone has access to healthcare. And Lord knows we can't do that in America. But second of all, I also wanted to give just a quick note here. We've talked a lot about Elizabeth Preliger, who did a fantastic job as the Solicitor General today. It also was a historic day. Chase Strangio of the ACLU becoming the first out trans lawyer to appear before SCOTUS today. He did a really good job in a very tough situation, having to follow somebody who's so good at this and has done it so many times, and he had to be doing it for his first time right after her. And he did a great job. He made us proud. And not only, and he's not the only trans attorney. I'm a trans woman who's an attorney. There are other trans attorneys in this country. He's not going to be the last to appear before that court. My colleague Ezra Young, as a trans man, just appeared before the Texas Supreme Court yesterday in a different employment case that has nothing to do with trans issues. So we're here, we're gonna be back. Let's celebrate this historic moment today and just take a moment to be proud of that.
Brittany
Yeah,
is like the best at finding a silver lining and like something to be happy about in an otherwise frustrating situation. And I really appreciate that. Completely agree. Historic day, first openly trans attorney to argue in front of the Supreme Court. He did a really fantastic job. I cannot imagine having to do that, especially for my first time, and especially following the Solicitor General who just makes it look so easy.
he really, really does. Constantly impressive, really constantly impressive. Um, I mean, I think the other, you know, there was, I do want to name too that Solicitor General Prelogar had a really beautiful response after being asked over and over and over again, like about regret and about, she talked about there's regret with any medical procedure and healthcare, it's always an option. But she also talked about, forcing children to go through puberty for their sex assigned at birth, like is also irreversible. And there's also, consequences for that. And so she was really able to bring in a case that's very in the legalese, right, about the people who are harmed by it. And when she had her rebuttal, she named the plaintiffs specifically and said, these are the people who are harmed, which I thought was really beautiful. Um, there's a question here about the influence of the Cass review, which was like this thing that was commissioned by the right wing to disprove the efficacy of gender affirming care, and it played a large role in this hearing today, even though it's not part of the fact record, right? When you appear before the Supreme Court, the facts have been established in lower courts, and so when you're there, you're using that fact record. Am I saying all this right, Jess? To
You
argue.
are.
Thank you so much. And that was not part of it. And so the fact that one of the first questions was about the Cass review and it was repeatedly brought up over and over, the Solicitor General would answer the question sheet, but it's not part of the fact record. And really what I think this pointed to is that they really wanted to dig in on the harms and the facts and the reviews pointing to the fact that this should go back to be developed and receive that heightened scrutiny. I think they proved that point over and over again.
Yeah, I think
Yeah.
the question was about how can we reverse the damage of anti-trans healthcare professionals and so-called experts, like those who put out the Cass report. It's really hard because what you have is a court that just wants to glom onto anything that suggests that like it's okay to ban gender affirming care and wants to ignore anything to the contrary. So it's every major medical association in the country supports gender affirming medical care, and they put in amicus briefs in every litigation. It's like hundreds of thousands of professionals in like the US are saying like this is the care, this is the standard of care, and the court, as long as like a court wants to ban gender affirming care, they ignore everything going on and they say, well, the Cass report. And then they misread the Cass report and say the Cass report bans it, which it doesn't. And so it's a real problem. You've identified a real problem with the anti-trans playbook, which is like they're just giving states the cover they need. And if courts want to, they can just follow that. That's also the problem that we're going back to the levels of review, rational basis versus intermediate. If the court is rubber stamping legislation, all they have to say is, look, here's the Cass report, right? They're not required to dig any deeper. Under higher levels of review, they have to dig deeper. And so all you need is even like a quack to say gender affirming medical care is bad. And that's enough for rational basis review. That's why the crux of this case is getting the court to scrutinize these laws, but the court does not seem to want to. And they've come up with all kinds of excuses why they're likely not going to. And that's the problem.
Yeah. I think what was interesting today was who we heard from, what we heard from them, and who we didn't hear from. So let's start with, Justice Gorsuch. He was the author of the Bostock decision, which established that it is illegal discrimination to discriminate against trans people in the workplace. And I think people were really surprised that he authored that opinion. we didn't hear any questions from him today. Brittany, do you want to share a little bit about what you thought about that?
Yeah, I found that super interesting. As someone who started my practice in Oklahoma, which is in the 10th Circuit, Gorsuch was on the 10th Circuit before he was on Supreme Court. He had a lengthy record in the 10th Circuit of taking pro-trans equality stances in legal cases that came before the 10th Circuit, which is why when I worked on the Tudor v. Southeast Oklahoma State case that we won the jury trial on, and then won at the 10th Circuit at Court of Appeals, and a trans discrimination case against a professor, um, when we took that case, we had high hopes because Gorsuch was in the 10th Circuit, and that we felt like if we got him on our panel, we had a chance to win. And that obviously this was all pre-Bostock. And so we had reason to believe that if he stays with where he's been his entire legal career and sticks to the principles he's always stuck to in these cases, I would expect him to side in favor of heightened scrutiny here and saying that this is a sex classification and it should be subject to heightened scrutiny. Um, I was hoping to hear some questions from him to gauge like the degree to which he's standing by his longtime principles, or to see is he now so in that right wing bubble that like now he's feeling the heat and needs to like fall in line with his buddies. So I'm really left to wonder like where he's now standing. And if he stays with where he's been, then my hope would be he gets through to Roberts or Coney Barrett, one of those two, who were the other two justices today that you could read some glimmers in there that maybe they could be persuaded.
Yeah, I mean,
Although I think with Coney Barrett, you're gonna say I think where she was at is actually helpful for us in North Dakota, but
sure.
may not be as helpful in Skrmetti.
Yes, so my Amy Coney Barrett, there were two very notable lines of questions from her. The first is that she asked both the Solicitor General and then Chase about de jure discrimination against trans people with like historical, which I believe is just like legal discrimination, right? Where did we have legalized or
It's
like
like
laws?
official legal in law
Yeah,
discrimination by the government.
give
Yeah.
me my law degree right now. So she asked about that, and she really genuinely was like, has there been de jure discrimination against trans people? Like, I know the last few years, but like, has this been a thing? And Chase was like, yeah, like the cross-dressing bands, and she was like, and the bands from the military, and she's like, the bands in the military I'd heard of, but I didn't know about the cross-dressing bands. And in my head I'm thinking like, what do you think they were trying to be arrested for at Stonewall? But okay, go off. And he also said that it was oftentimes like trans and gay and lesbian, the laws targeting the LGBTQ community are lumped together. But she did bring up a few times the parental rights argument, and she kept asking, if this doesn't get heightened review because we don't find that it's a sex classification, is the parental rights argument still open? She asked that a few different times. And so my thought is that maybe in learning about the de jure discrimination against trans people, wild to think that she just thought it came up today. She'll be horrified to learn about Nazi Germany. But like, if she just learned about that today, maybe she'll be more inclined to understand the long history of this discrimination and realize that it's not new. But my inclination is that she's going to write like a partial concurrence, basically saying that like, but this isn't necessarily done because parents still have the parents' rights argument. I'm hoping that Gorsuch was quiet because he didn't, he is where he is and he's going to remain there and he didn't need to ask more questions. That's my hope. Kavanaugh asked about sports and I wanted to throw a beer at him. He deserved it. And I just, every time he talks, I'm like, I'm smarter than you. And I can't believe that you just failed up to the Supreme Court. Go ahead.
Kavanaugh highlighted, I think, the biggest risk that exists in this case because Kavanaugh kept saying like the Constitution is silent on this. And I want to explain what that means. So in life in general, anytime a law is passed that targets a group of people, the Equal Protection Clause is triggered. The Constitution is never silent when a group is targeted, right? Like that is what that clause exists for. So for him to say over and over again, the Constitution is silent on this suggests that he wants to roll back the application of the Equal Protection Clause. And Ketanji Brown Jackson kept saying, I'm getting nervous here. She kept saying that
Yeah,
exactly. And that's
did.
what she was getting nervous about. Like, what do you mean the Constitution is silent? Because until today, anytime a law targets a group of people, the Equal Protection Clause has something to say about it. And Kavanaugh stuck with that line. And I think that's kind of the biggest risk here, even beyond gender. It's a huge risk for trans people. It's a huge risk for gender affirming care and for trans protections moving forward. But it's a huge risk for like all of us because what does it mean if the Constitution's silent? And there are judges. There's two ways judges go on this. There are judges who don't believe there should ever be heightened scrutiny based on sex. And some judges feel that like that was wrongly decided, that should never have happened to begin with. There are also judges who feel that no provision of the Constitution does anything if what we're talking about is something that's like been accepted all along. And that includes both like at the time of the framing and at the time of um the 14th Amendment, which we know happened after the original framing. If something was allowed or something was kind of like not an issue for those framers at the time, then the Constitution is silent on it. And that is the thing that I'm really worried about because that's the direction the court is headed. So you can target gender affirming medical care, even though it's the Equal Protection Clause has nothing to say about it because the framers didn't care about it. And so like think about the Pandora's box that opens. And that's what Kavanaugh was saying without explicitly saying it. And that's what Ketanji Brown Jackson was like, whoa, whoa, whoa. Because what she's saying is like, look at Loving v. Virginia. Like at one point it was totally okay to ban interracial marriage. Are you really saying that the Equal Protection Clause has nothing to say about that? Um, it's really that's the part where I think she was scared, and I'm right there with her.
The justices appointed by Democrats were like flabbergasted with the lawyer from Tennessee, because he was making very nonsensical circular arguments. My daughter does this thing where when she's crying, I'll say, "Are you sad?" And she'll say yes, and I'll say, "Why are you sad?" And she'll say, "Because I'm crying." And I'll say, "Why are you crying?" And she'll say, "Because I'm sad." It was like that, right? Like it's each one explains the other thing, but it's none of it's an answer. Um, and so I mean, she was getting nervous because talk a little bit about the Loving v. Virginia, which is the United States Supreme Court case that struck down miscegenation laws or laws that allowed interracial couples to get
I
married.
think Brittany wanted to add something
Go
about
ahead,
the
Brittany.
14th Amendment.
Real quick, something that I wish had been brought up in the briefs, that my colleague Ezra, who I mentioned earlier, wrote about in a law review article. The history of the 14th Amendment. It turns out one of the key people who testified to Congress that helped get the 14th Amendment drafted and put into law was a Black trans woman from Tennessee, no less, who was
Wow.
who was part of a group of women that were making flags for Union soldiers, and she was gang raped along with some of her friends. I'm sorry, this is really terrible fact pattern, but within weeks of that, because it was like people who were former Confederate soldiers and state officials who did this, she traveled to Washington, D.C. A Black trans woman in the 1860s testified for hours in the US Congress to a bunch of white men about how she was treated. And her story was part of the impetus for the 14th Amendment.
So
So
there's your history and
even if
tradition.
we look at history and tradition of the 14th Amendment says they meant to protect trans people.
Love that so
And
much.
someone asked in the questions, despite our adoration of the Solicitor General, didn't she drop the ball a bit on questions of like, are transgender people a discrete and insular minority who've been long targeted? Like, yes, I would agree that she was not able to answer that question well. And I wish she had a lot of the knowledge that Brittany's dropping on us right now. Because that if you're going in front of a court with a history and tradition lens, it's stories like the one Brittany just brought up are super important.
I will say, yes, I agree with you. She did drop the ball on that, but there was a different question about, did anyone bring up intersex individuals? And she did mention, that Tennessee was trying to say that the reason that they have this law is because of the harms of gender affirming care, which include loss of fertility. And she said, yes, but one of the exempted things in their law is surgeries on infants who have intersex characteristics, which of course could affect their fertility. So I was really grateful that that was brought into the conversation. And she did drop the ball on kind of the history, and I'm really glad Chase was there because I think he came back and was able to provide a lot of that. Jess, I want to come back to you because I do think we should go back to the Loving v. Virginia line. I think it's notable that at least two members of the court are in interracial marriages, and so it wasn't just Ketanji Brown Jackson, but it's also Clarence Thomas. And to kind of hear the not express there was no real argument against how is this not like Loving v. Virginia? I mean, she asked the question a bunch of times and they didn't really have a good answer.
So the logic in Loving v. Virginia, like what happened in there are two really stark comparisons with Loving v. Virginia. The first is, the court was like, we need to shy away from this because there's complicated medical questions. In Loving v. Virginia, the crux of the argument in favor of banning interracial marriage was based on science and data that the court would have had to delve into. And so there's often science and data used to defend discriminatory laws and policies. That's so common. So if you say we're just going to shy away anytime there's science and data, you're just going to allow discrimination to go unchecked, right? There's always quacks and
there's always a quote unquote
there's always a
reason.
quack.
Yeah,
There's always a quack. The other thing it had in common was basically they made the argument that because white people can't marry other races and black people can't marry other races, it's not race discrimination because the races are treated the same. And that's the argument in Skrmetti, because boys can't get gender affirming care and girls can't get gender affirming care. It's not sex discrimination because neither of them can get it. They rejected that argument in Loving and should reject it here, but yeah.
And I think
since I know we're getting close to time, should we switch over to North Dakota and Minnesota and questions?
yes, I absolutely think we should. Let's go to you, Brittany, to talk a little bit about our North Dakota case, and maybe talk just a little brief background on it, but answer this question more deeply on if the Supreme Court upholds Tennessee's ban. What do you think that means in our North Dakota case?
Yeah, so for one thing, we're set to go to trial in our North Dakota case at the end of January 27th. We just had a summary judgment hearing in Bismarck last week. It went well for us. It seems the judge is not inclined to get rid of the case on summary judgment and is likely to let us go forward and make our arguments at trial. And I also want to say, one of the big differences in our case is that we are doing it under state law, and Jess mentioned this earlier. So we filed this in state court, and we're making claims under the North Dakota state constitution, which is not, a carbon copy of the US Constitution, and the rights are enumerated a little differently. There is an equal protection claim in our case. And contrary to federal law, where sex is not necessarily given the highest level of review of strict scrutiny, under North Dakota law, sex is given strict scrutiny under their case law. So that's one big difference. And number two, we've also made a parental rights claim in our case. And that seems to be our conservative judge in North Dakota has glommed onto that claim and has indicated that because that fundamental right is at issue, that this law will be subject to strict scrutiny. So we've kind of already hit a point where our judge does agree that this law should be subject to this stricter scrutiny. That's really what the issue before the Supreme Court kind of was today, is what level of scrutiny applies. We've already got our trial judge there that he needs to be looking at this more deeply. And now it's about presenting all of the evidence at trial to move him along to say, okay, this law was not narrowly tailored to address the concerns of North Dakota legislators. and in fact is way too broad. And this is something that came up through oral arguments today. And I think one of the better arguments that Preligar was making was that, look, if they just wanted to regulate because of legitimate concerns that say we don't want, a 12-year-old to be able to get this care without having gone to any kind of therapy, without getting a diagnosis, or, without making sure it's a licensed endocrinologist. Those things they could have done, but they didn't. They said, because we're scared a person might go to a quack doctor on this, we're just going to ban it. Well, like that's not okay. You have to make that law be more narrow so that you're not cutting off the care to the people who really need it and have a right to it, while, maybe addressing any whatever legitimate concerns you may have. And so, and Preligar pointed to West Virginia, where they had a doctor who was like the head of the state senate there, who like went and rewrote their law to not be a blanket ban and to be more of a, let's put some guardrails, let's make sure you had your diagnosis done, let's make sure you're being seen by a multidisciplinary team. All things that are already going on in North Dakota and that all the testimony in our case supports. So there's reason to believe that Skrmetti won't really impact us, at least not in the trial court level, because this decision in Skrmetti's not coming down until June, likely. I mean, it could come earlier. Nobody expects it till June. If we're at trial in January, our trial judge is likely to have to make a decision before June. So while he may have signaled that he sure wants to get a ruling in Skrmetti to help him make his decisions, and help give him some guidance, like I think he's going to be stuck with having to decide after our trial and based on the record of our case in front of him and not what's going on elsewhere.
That's super helpful. And I love a good timeline. And I do want to follow up because you had mentioned the Black trans woman who had testified. Her name is Frances Thompson. And I wanted to say that out loud so folks can hear the name and look her up on Wikipedia. Yeah.
I posted the Wikipedia link in the chat if people wanted to see it.
For all our podcast listeners, they can go find that.
Yeah.
So I'm going to switch us over to questions. I'm going to start with this first one. Are there any states that have a law saying gender affirming care is explicitly a right for people in that state?
Kind of.
I was just going to say, yeah.
So any state, not really. So New York just passed an equal rights amendment that is trans inclusive. I would expect that courts would read that equal rights amendment to include protections for gender affirming medical care. I can't guarantee courts will do so, but I know that was part of the intention in passing the equal rights amendment with that language included. Minnesota has some statutes supporting the right of Minnesotans to gender affirming care. That's not as good as an amendment, a constitutional amendment. But we do provide certain protections for gender affirming care here in the state. For example, we won't participate in investigations of providers who treat minors for gender affirming care. We won't voluntarily extradite providers if there's any sort of criminal investigation. So we do have protections for gender affirming care. We also have there's state constitutional protections, like Brittany was explaining. Whatever happens in Skrmetti, states wouldn't be forced to follow. There's a scarier question though of what happens at the federal level, and there, I don't know if we want to go to that question, but
I think it's worth going to. Yeah.
So there's this clause of the US Constitution. I'm sure Brittany will have like a helpful story. So I'm gonna give like bad news, and then Brittany's gonna like lighten it, like lighten things up. So there's the supremacy clause in the federal constitution, which basically says that federal laws and the federal constitution trump state laws and the state constitution. So there are things that could happen at the federal level that state protections wouldn't protect us from. For example, a federal law criminally banning gender affirming medical care would be really tough to get around based on state level protections. Um, Trump has a lot of tools in his tool belt. I think his most potent one is fear and chaos. And so, like, he tweets a tweet, and everyone's like, oh my God, do I still have rights? And people are right to worry. I mean, he's a loose cannon. He's got the power of executive orders that can also create chaos, where he says, he instructs an agency to interpret laws to ban certain rights, to roll back certain rights. And so, Trump does have a lot of tools in his tool belt. Minnesota cannot protect us from the state level protections cannot protect us from all of them. He hasn't used those tools yet. So the thing I always say to folks is like, don't take away your own rights. Right now, you do still have the right to gender affirming medical care. You do still have the right to get it and to provide it. You still have the right to, you know, uh, change your name on your passport and other federal documents. There are rights that you still have, and just because it's not like they go away the day Trump's in power. The things all the things he does, they're going to get challenged in courts. We're going to see a lot of litigation. But I don't want to mislead folks. Like, there are things that could happen at the federal level that state level protections won't protect us from. And now Brittany's gonna make it less dire.
I'll come in with the slightly good news, in that
Okay.
as of yesterday, we do know that Democrats in the US House are up to 215 seats, and that with Trump's appointments to his administration, therefore like pulling 3 Congress people out from the Republicans, when this session starts, the Republicans will have a 217 to 215 majority in the House. So, any kind of broad legislation they do, they cannot afford to lose like even a single vote, basically. So, like, they're operating on a very, very tiny margin. So it's going to be very important for people to stay attuned to what's going on. And like Jess said, don't assume that because he tweets something, it's the law yet. Pay attention to what's actually happening in Congress. Because for them to outlaw this care federally, it will have to originate in Congress, for the most part. There's some things he could try and do. Those will be difficult, but I think to really do it right, they'd need it to do it through Congress. Um, and so it's going to be important that even if you live in a red district, that you contact your Congress people. One thing that I hear from elected officials, and EMQ, you are one, so I'm sure you know this, like, so many times they don't hear much about very many issues. And if they get 10 calls or 10 emails, that suddenly kind of perks them up, like, oh, like some people are interested in this. I need to pay attention. Because it's rare that they get that many calls and emails about an issue. So use your power as voters to say, hey, you don't have to tell them who you voted for. If your congressperson's a Republican, you don't have to present yourself as I'm a Democrat or voted against you, or I'm a progressive, or I'm whatever. One of the things I do when I write Congressman Stauber up here on the Iron Range is I wrote him about the bathroom issue a couple weeks ago, and I just said, look, as a voter this year, I voted for a slate of candidates who are wanting a more prosperous Minnesota for everyone. And so I used kind of that prosperous language, things Republicans like. They like rich, prosperous. They like the money. So I wanted a more prosperous Minnesota for all. Why aren't we focused on that instead of these dumb bathroom issues? So, like, find ways to talk to them in their language and just say, look, this is not where I want you to be focused and using your time. That's not what we elected you to do. So be ready to do that, because you really can make a difference when the margins are that tight. Because if even 1 or 2 Republicans defect, if they try and push these laws, it will stop it. So pay attention, maintain your power. You have a voice, keep using it.
Yeah, that's great, Brittany. I think another way, because there's a question, how can citizens fight or resist this? And I think that went straight to the heart of that question. There's other ways too, like recognize attacks on transhumanity for what they are. Like if debates about it even came up for no reason in Skrmetti, debates about trans women in sport. A number of justices asked, like, well, what will this do for sport? And it's like, are we really going to harm kids to the point where we know it increases suicidality because we're concerned about women's sport? Like, you don't do any of the other things that help women's sport, like make sure like harassment laws are enforced and funnel funding over to women's sport and support women's coaches. Like, there's so many things you could do to support women's sports, and you're not doing them. But all of a sudden, Justice Kavanaugh is like the champion of women's sports, and it's absurd. And so I think one thing you could do is kind of recognize these types of arguments for what they are and what they do and push back. Like, why, like, um, consider like why are we so hell-bent on banning trans people from things that are so important to just society, to living your life? Bathrooms, right? Like you can't really go about your life without bathroom access. So I think another way is like to see these for what they are and not to kind of say like, well, I'm okay with discrimination in this area but not this area. It's like think it through, think about the connections. You can feel how you want about discrimination, right? Like if that's how you feel, so be it. But take time to think it through, take time to think through the nuance, and take time to think through the implications of these other policies, even if they're not directly on point with healthcare.
Absolutely. I mean, I think that we have arrived at a place where, this is what's so hard about working in the space that we do, is that all of this isn't just like, okay, and then once we're done attacking trans people, we're done, right? Like as we talked about with Skrmetti, it's undermining the entire idea of protections on the basis of sex, right? And when we'll have another podcast and talk more about our Cooper case that we had at the Minnesota Supreme Court. But like that, the underpinning of all of that is, if we have a good reason for discriminating against people, not just trans people, but anybody, like, then you should let us do it, right? And so I think that gets lost a lot, is that like, it's just trans people first. It's not the last. And so, seeing this fight for what it is also really helpful in maintaining the vigor that we're going to need to fight and resist and stand and defend trans people, because it's just the first step.
Hey,
Jess,
one
go
other
ahead,
quick
Brittany.
thing. And if you are trans and you're watching or listening or whatever, one of the best things you can do is to just keep living your life with joy and positivity in the face of all this. Because nothing pisses them off more than the fact that we can go on living happy lives in spite of their hatefulness. And like that is like the biggest, most revolutionary thing you can do. So don't feel like you have to solve everything and you have to be at the front of every issue. Like be you and just live with love and joy and be a good person in your community, so that when those other people that see you and interact with you, they're more likely to want to take up your cause if they do come after you. So like build community, be positive, don't let the bastards get you down.
Yes. And there was a comment that said, even if it were just trans people being attacked, and then they were done, it would still be the right thing to do to protect trans people. And yes, 100%. That is very, very true. Well, Brittany or Jess, do you have any closing comments other than the beautiful ones you just gave? You can.
I would just say I'll do a takeaway. I'll let Brittany do the last takeaway because she's so much better at these than I am. I'm like doom and gloom. What I will say though is like what I hope folks take away from this is like whatever happens with Skrmetti is not like that's not the day your rights are all gone. There's going to be a lot of scary headlines. The headlines aren't always accurate to what the opinion says. It's terrifying, and I want to validate that. Like people wake up in terror every day that Trump's in power, and it's not just trans people, right? It's also undocumented people. It's a lot of people. And so I want to validate the fear, but also just say like it's the worst case scenario isn't always happening. You still do have your right to health care. That was true yesterday, and it's going to still be true tomorrow. We're going to keep a close eye on what the Trump administration does, and we will keep you all informed. And a lot of folks ask like, okay, well, the Minnesota legislature's changed, the elections weren't great. What is gender justice going to do? And the answer is we're going to keep doing what we always do. We're going to keep litigating our cases. We're going to keep supporting trans rights, abortion rights, and we're going to keep on doing what we do. So, yeah, please let us know if you have any other questions. But we are closing out. But Brittany's going to give the closing because she's just somehow finds an optimism here. It's great.
Hey, it's not always easy. I have my moments too. I'll admit to y'all, I have my down days. They're not all rosy. But I do want to remind people to make sure you do keep some hope alive, because we are in for an onslaught of some negative stuff, as Jess said. It's not going to stop here with this one case. It's not going to be only this issue. But we've made it through a lot of tough times in the past. We've made it through tougher times in the past. And when I look back, like when I started living authentically in 2005, I did not think I was going to have the successful life that I have now. I didn't think I would ever find a man who would love me for who I am. Now I've been married to my wonderful husband for 7 years. Things don't always go in a straight line towards the best outcome. There's oftentimes dips. As an Oklahoma City Thunder fan, our coach, Coach Dagnott, always says progression's not linear. And so I think that actually applies here too. Progress isn't linear. Like sometimes we have backslides and there's a reactionary movement because we made so much progress. And so understand that these fights aren't like a 1 day, 1 year, 1 term fight. These are long fights. Like these are generational fights. And we've got to keep our positivity about us and keep living and moving on, because we always have and we always will.
Thank you both so much. I will, my minor addition to that is find your community, find your people and be with them. Isolation really truly will accelerate our slow descent into whatever, because we'll feel alone, and it will feel like there's nothing we can do, and there's lots we can do. And so it might be hard, but it's easier together. And that's how we keep each other alive and joyful and have our cups full, is to be with one another. So that would be my only addition to the beautiful things that you've said. Thank you so much for joining us this evening. Like Jess said, like Brittany said, we will keep you informed. We will continue to be here. We're always here. We'll bring great knowledge on the legal structures and systems and historical facts about awesome trans people and bite-sized nuggets of inspiration to leave. That's basically the gender justice mission statement. Thank you so much, and we will see you next time.